Dohrman v. Swaney. In 1984, George Dohrman III was a 40-year-old married physician with two sons, George IV and Geoffrey. Dr. Dohrman befriended his neighbor, Virginia Rogers, a wealthy 73-year-old. Both of the parties resided in the Duke Tower in Illinois. However, Mrs. Rogers' apartment was substantially larger than Dohrman's apartment. Mrs. Rogers did not have any children or immediate family, and over time, Dr. Dohrman and Mrs. Rogers began to grow closer and closer. Sometime in 1997 or 1998, Dr. Dohrman approached Mrs. Rogers about adult adoption. Dohrman testified in deposition that Mrs. Rogers often said she regretted not having any children, and Dohrman wanted to give her the family that she never had. After a number of failed attempts on Dr. Dohrman's part, neither party adopted the other. In February 2000, Dohrman consulted an estate planning attorney regarding how to create an agreement if he wished to receive something in exchange for something after a person died. The attorney provided Dohrman with a skeleton agreement, which Dohrman later modified. On April 1, 2000, the 89-year-old Mrs. Rogers signed a contract. 2 years later, she was then diagnosed with Alzheimer's disease. No witnesses were present at the signing of the contract, and Rogers did not consult her longtime attorney, Mr. Thomas Swaney. Oh yeah, the defendant. Regarding the terms of the agreement, the basis of the contract stated that Dohrman would receive Rogers' cash, apartment, and personal property totaling nearly $5.5 million in exchange for Dohrman incorporating Rogers' surname into the name of his two sons, as Rogers wanted her surname to continue after her death. However, sly dog Mr. Dohrman only used Rogers' surname as an additional middle name for each son. In November 2004, Rogers transferred ownership of her apartment to a trust. In March of 2008, Mrs. Rogers was declared a disabled person, and Swaney was appointed as a guardian of her estate. After Rogers' death, Dohrman filed a 5-count complaint against Swaney, the executor of Rogers' estate, seeking a declaratory judgment that the executed agreement was valid and enforceable, and that Rogers transferred her apartment onto the valid trust was void. Swaney filed a counterclaim alleging fraud and asking that the executed agreement declared invalid and unenforceable.